So, hello everyone, good morning. I'm Bruno, I'm legal coordinator at the German-Brazilian Chamber of Commerce here in São Paulo. And I'd like to welcome you today to the webinars about crisis management, how to safely navigate your company through cross-border corruption investigation. And we are here today with our fellow colleagues from Lefosse Advogados, Juliana Daniel and Ludmila Groch, and from Linklaters, LLP München, with Kerstin Wilhelm. If you have any questions about the presentations, please type in the Q&A option here in Zoom. And without further ado, Juliana, you have the floor is yours, and thank you.
Thank you very much, Bruno. Good morning or good afternoon, everyone. Welcome to our webinar on crisis management. I'm Juliana Daniel, partner of the Compliance and Regulatory Investigations practice at Lefosse Advogados in São Paulo. And I would like to start introducing our brilliant speakers and thanking them for the opportunity to discuss such a fascinating subject. So I have here with me Kerstin Wilhelm, who is the partner and co-head crisis management and compliance in Germany at Linklaters, and also Ludmila Groch, who is the partner of white-collar crime, anti-corruption, compliance, and regulatory investigations here at Lefosse. So welcome, Kerstin and Ludmila. Thank you, everyone that is joining us today. I'm delighted to take you through a session on crisis management. The objectives for today's sessions are to provide you with an overview of what good crisis management is and to empower you to quickly respond to a crisis situation. As we all know, crisis can appear in various forms, including a pandemic form. And today we want to focus on crisis resulting for companies from cross-border investigations. All over the world, investigations in corporate law enforcement and regulatory bodies are on the increase and are gaining high-profile media focus and coverage lately. As we all have seen happening through the past years, corruption enforcement can be multi-jurisdictional, multi-regulator, and subject to extensive media coverage. And it can arise in a range of circumstances for a range of different reasons and take different forms as well. Just to give you a couple of examples, investigations can be regulator prompted, self-prompted but motivated by a regulator. Investigations can also be public, often crisis motivated, non-public as an investigation routine or behind the scenes. They could also be internally or externally conducted. The reaction and best approach in each case will depend on the circumstances and of the reasons of the investigation. So how can such a crisis start? Carol, I would like if you could please share the PowerPoint, and we should skip to the second slide, please, the next one. Yes. Here it is. Thank you very much. So here's a case. You are the CEO for Latin America of ABCSL, one of the leading manufacturers for electronic goods in Brazil. Over the past years, sales and profits have continuously increased, and the business outlook for the upcoming year looks promising. ABCSL is part of a wider group of companies with subsidiaries in more than 40 jurisdictions, including the US, and the ultimate parent company being ABC Germany AG in Germany. Well, it's 8 a.m., you were planning to get into work early, it's your last week before a well-earned break. Suddenly, your mobile phone rings. It is the doorman at your main office building who nervously tells you that there are several prosecutors and police officers requesting entrance to the building. The doorman does not know what to do and is clearly overwhelmed by the situation. Unfortunately, the mobile phone connection is very poor, and the only thing you can hear before the connection breaks off is search warrant and corruption. What a crisis, huh? So, Ludmila, this is a critical and stressful situation. In our view, What should companies do?
Hello, good morning and good afternoon. Thank you, Juliana. Thank you, Kerstin, for being together here discussing such a great matter. I would like to thanks to the Chamber also to providing this possibility of us to be together and the technology that can bring, for example, like me and Juliana in São Paulo, some of you, I don't know, all over, and Kerstin in Germany. And so we are so distant and so close at the same time. So it's very good to be possible to discuss with you this matter in this way. Well, the crisis, as you said, Juliana, crisis is not the question when you talk about crisis. And here we are talking about corruption, but we are not just talking about corruption when we think about crisis. The question here is not if, the question here is when, because we know that running a complex business, thinking about complex, different jurisdictions, if you're thinking, if you work in a company with different, that has operations in different jurisdictions, we are talking about probably some kind of crisis. In this case, we are talking about corruption, and we are going to use this example here. And just one thing, like we use this example, and we were like very good in the example because it is 8 a.m. and your phone rings. Usually the real time, it's 6 a.m., 6:05, 6:10 a.m. And then the doorman calls you, because usually the operations here in Brazil, when you're thinking about federal prosecutors or police, we are talking about 6 a.m., not 8 a.m. So we are using the example here of corruption, but we could have started these with different types or of crisis. But the first question, if you think about this, the first moments, the first hours, I think we are going to divide our presentation here, me and Kerstin, in the first 48 hours. And then we are talking about the process of internal investigation if you need so. And then we are going to talk about self-reporting and the communications with the authorities. But if you're talking about the first 10 hours, if you're thinking about down rate, so it's the first 10 hours, not just the 48. The first question here is, did you have a plan, a crisis plan before or not? If you do have, and you should have prior to the possibility, considering that crisis is when and not if you have this plan, you would have the phone numbers of 3 most important contacts in your company, and one of them is the external lawyer that should be contacted at the very first moment after the doorman calls you. So you would have in front of you a list of 3 focal and more important contacts in the company. And so while you were exchanging and putting some clothes to move forward to the company, you would have called probably someone that can be closer to the company than you, and the external lawyer. The second thing that it's very important on that moment, and if you have the plan, it is easier to put in practice. If you don't have the plan, you will have to do this right on time with the doorman, and is to understand which authority is reaching on your door. Because when we talk about search and seizures and down raids in Brazil, and Kerstin will tell us what is important for her in considering Germany, because we are talking about a subsidiary here in Brazil from a German company. So in Brazil, it can start, just like Juliana said, from different authorities. It can be a police, a federal police, authorized, of course, by a judge, always authorized by a judge, but a federal police. It can be federal prosecutors in an investigation conducted by the prosecutors. It can be IRS, for example, starting something with an authorization, a judge order, but at the same time, it's just IRS. It can be CGU or AGU together in a anti-corruption together with the police. So, and it can be CADE, it can be the antitrust authority, for example, conducting this. So the first thing that in this plan should be very clear is that in this meanwhile, while you are going to the company, you have to understand what and who is downgrading the company. So it includes reading the search and seizure documents, taking picture of everything, and asking, this is important also, asking for the authorities kindly if can wait, and usually they wait, if they can wait for the external lawyer to arrive to the company. So this is a very important moment because you have to remain calm, and usually you are talking to the doorman by that time because no one is there yet. So you have to make sure that he's going to remain calm and gather the most information that you have so you can put in practice the plan. And there's nothing wrong with this plan. We are not hiding the company. It's important to tell here that when we say gather information, trying to take pictures, it is the opposite of wrong. It's just like getting all the data and information that you need to put in practice the plan, or to put on a plan right on that moment. And the plan is for what? I think that I'm still talking about the first 10 hours, the moment of the downgrade. And the plan is for what? It's because nothing, the first rule, nothing can go out from the company. Nothing can be seized without the acknowledgement of the company. So if the law enforcement agencies, if they're collecting documents from the companies as gadgets, computers, emails, physical documents, everything should be copied. The company must know everything that left the company for the investigation. So the worst thing that can happen here is if you don't know what the law enforcement agencies got from the company. Because if you don't know what is there, you cannot examine that. And so during the next moment of the internal investigation, you are not going to have anything to check. So the first thing is nothing goes without the acknowledgement and without having a copy. Sometimes they let you stay with the original and they back up your things and take a backup copy. Or sometimes you have to back up things and they take the original. It depends on the limits of the search and seizure. The second rule, everything that goes, everything that is seized, searched and seized must be included in the limits of this authorization, the judicial authorization. So it's very important for us, the lawyer and the focal contacts and the main important, the group, the crisis group. It's very important to know, to acknowledge the limits of the judicial order. So if the judicial order is, for example, seeking for one executive, so they are just allowed to check things from that executive. They are not allowed to check things that are in no way related to that executive or that client or that contract. So it is important for us to make sure that everything that is being collected is related somehow with the limits of the judicial order. Okay, so once they have everything, once they are collecting and backing up everything, it is important to make these limits, put in on order. If you have, for example, the extra staff from the company, people talking and walking around, if you do have the opportunity on this moment, and it's a very sensitive moment, it is, if you have the possibility, if this group has the possibility, it is important to avoid other staff members from the company to arrive. Just ask them to wait outside until everything is finished. Usually it takes, in a normal search and seizure operation, it takes, 4 or 5 hours, one period of the day. So it's better to avoid people coming and going, because we are starting to think here in a communication plan. This is the next step. So once we are over from the 10 hours, for example, so then you have to put in practice the communication plan. What are you going to communicate? either to your clients, to your collaborators, to staff members, to your stakeholders, to the board, or to the board. What are you going to communicate with media? So the communication plan is very important. Usually here we work together with an RP company, but if you don't have, it can be internally also. But the important is, once we understand from who the order is coming, what kind of investigation we are talking, what kind of crisis we are talking, is data breach, is corruption. So once we are aware of that, once we have everything that has been collected, backed up, so we have material to start and to take the limits of the investigation, then we have to have this communication plan. Sometimes if you are talking about public listed companies, for example, you also have to have a very specific communication. It's not an option. Maybe you have to provide to CVM or to your investors, you have to provide them with information, with a communication, a relevant fact communicated for the investors. So we can have also not just the communication for media and for outside people, but you need sometimes to have a very specific communication for some regulated markets, for example, financial markets. So you have things that you have to consider. So once you put up in plan, you have a plan, you have a committee, a crisis committee, you have put up in practice the communication plan, you have backed up everything. So the next thing that you are going to have to do is, what are we going to do? So this 48 hours is gathering, containing the information, controlling the information, and gathering data. Then we are going to move to the next one, but I don't know, maybe we are talking about Brazil, but in German, Kerstin will be there. Like, for her, the time it's going to be worse than for us, because then she'll have to stay all night long awake, because we will be discussing this while the night time from Germany. But I think that it can be something during this 48 hours also.
Yeah, it seems to me that these first 48 hours are very, very critical to the cross-border investigations. And I have a question to Kerstin. Let's suppose we're talking about a search that has taken place in Brazil, in the Brazilian subsidiary. This might be a spillover effect for the parent company in Germany. So Kerstin, should you please shed some light on the German perspective and what should be done at this stage?
Yeah, thanks, Juliana. Happy to share my views from the German perspective, because as you rightly said, there is always the risk of a spillover effect if something is happening in one jurisdiction. A lot of companies, if they are in such a situation that they are being searched in one country, they sometimes believe and sometimes they just hope that it's just an isolated risk that is just limited to that particular jurisdiction. But I think in reality, the situation is different, because for globally operating companies, as nowadays basically most of the companies are, it's almost impossible to contain a risk just to one jurisdiction, because you have various subsidiaries, because you have supply chains all over the globe, because you have employees who have various roles, who have responsibilities, not only for a specific entity in one specific country, but responsibilities across business units which stretch across various jurisdictions. So there is always the risk that an incident happening or starting in one country will spill over to another country. And there is first of all, well, the reputational issue around it. When you are, for example, as in this case that we build, you've got the parent company in Germany and the search happening at the Brazilian subsidiary. There is reputational issues. There might be financial impacts, but also from a legal point of view, the issue might have severe impacts on other group companies and also on the parent company. And also, if something like this is happening, then this may also divert senior management time from kind of strategic objectives of the business, meaning that their mind is focused on kind of dealing with a crisis and not on getting the business done, basically. So it's very crucial that you, get on top of things quickly, that you are in control of the situation. And at this early stage, when we're talking about the first 10, 24, 48 hours, it's often not clear whether the misconduct only affects one country, here Brazil. It's possible that other employees from other jurisdictions potentially or other group companies are involved. And what is also not clear is whether the incident that the Brazilian authorities are investigating, whether this is just one single case of misconduct, or if the issue under investigation is kind of part of a larger scheme which applies throughout the organization. And if there are ties to Germany, be it through individual perpetrators who act from Germany or who are German nationals, or if German legal entities are involved, which are parties to contracts that, for example, might have been obtained through bribery, then it's clear that the issue is not limited to Brazil. Because there's the risk in this case, with view from Germany, that obviously the German authorities, they might potentially also be already investigating the matter without the German entity knowing, because in most cases the authorities, they investigate for rather months than weeks until they have sufficient information together and start the dawn raid at the company. And it might also be, even if the German authorities aren't already investigating, it might be that the Brazilian authorities will at some point in time inform the German authorities about the incident, and then the German authorities will potentially start a criminal investigation in Germany against German individuals or also against the company, because very often if the misconduct spreads over various jurisdictions, then the authorities, they will ask for information, they will ask for documents through the regular ways of mutual legal assistance. So in such case, there is in particular a liability risk if individuals who hold a management function in Germany, if they in the end are held criminally liable, because in such case under German law it's possible to impose a fine against the company, and there's also the risk of disgorgement of any profits. And this might reach very high amounts, because basically the disgorgement of profit doesn't know any upper limit, so to say. So it's always important in such case, even if you think it's just one authority investigating, that you also watch out to ties to other jurisdictions. And in particular, one jurisdiction that our clients often have in mind, mainly because the consequences are always so severe there, is the United States, for example. And because not only the consequences are always so severe, it's also because the US authorities, they assume jurisdiction very easily, because in bribery cases, it is already kind of sufficient if payments have been made in US dollars or emails sent via US servers. So it's kind of very easy to be caught by the provision of the US FCPA. So that's something certainly that companies should always have on their agenda. But coming back to Germany, I mean, corruptive behavior, if there is one, this might also have an impact in other fields of laws. One typical case that we often see is that the amounts that have been paid as a bribe, they somehow find their way into the books and records of the company, and then they are declared, sometimes declared as deductible operating expenses in the tax declaration, which means that the tax filing is wrong, and which means that even if the bribery took place, whatever, a couple of years ago, under a completely different management of the company, the current management, even if they haven't been involved in the bribery, they can be criminally liable for tax evasion if they do not act now and correct the tax filing without undue delay. So in these cases, it's always important to seek advice quickly. And many of the points that Ludmila has mentioned for the first 48 hours, they're equally true for the German side of things, because you always have to remember that in such a scenario, people are under stress, and very often or almost never such stress leads to good decision making. So one of the most important things that you can do as an in-house counsel, and that we can do as external counsel, is to help people within the organization make the right decisions at the outside. Because if you get something wrong at the outset, this will come back haunting you at a later point in time, and we've seen that happening too often. Although we of course also realize that there are always tensions between the different stakeholders involved that need to be managed. And it's crucial at this stage. I think it's a global view. It doesn't apply to Germany only, that companies don't lose the focus, because also from a German point of view, you need to start looking at the most imminent things you need to do and that you need to deal with, identify the problem, work out how to fix it, and preserve evidence. And I've once seen a quote from the one of the former CEOs of Xerox, Anne Mulcahy, who once said, and who she made the example of a cow that had fallen into a ditch. And she said, in such a scenario, first you need to get the cow out of the ditch. Second, you need to find out how the cow could get into the ditch. And third, you need to make sure that you do whatever it takes so that the cow doesn't go into the ditch again. And this, I think, very well translates into such crisis scenario, and because it illustrates also mistakes that are often done, because often people just directly jump to the second step and forget to fix the immediate problem. Because if you are in this dawn raid situation, and if you realize it's about kind of payments going out to entities where they shouldn't go, then it's more important not to start looking. I mean, it's also important to start looking into how this could have happened and how many people are involved and so on. But it's kind of at this stage even more important to stop such payments going out in the future, because if it's something that happens whatever once a week, then you need to kind of stop this and make sure the problem doesn't persist, so to say. Also, when you, and we will talk about that shortly, and Ludmila will talk about the importance of how to scope and conduct the internal investigation. But just only a few words here. It's always important when you start investigating things. You need to plan what you actually want to investigate. You need to decide what the purpose and what the objectives shall be. And Ludmila also said, and this is true also from my practical perspective, that it is often underestimated how important communication is, and how difficult the dilemma might be that companies can find themselves in particular here in a case for the German entity, who at this stage just knows that something is going on in Brazil, but the German people, they don't know what actually is happening. They don't know the details. They don't know to what extent they are affected. And still, I mean, news travel fast these days. I mean, this will be everywhere in the internet if kind of the press hears about it. And then also the press will call the German company, and they will ask questions, and employees will ask questions. So also in Germany, the company will be required to make any statement. And in this respect, I mean, the dilemma is always, I mean, you don't have knowledge or incomplete knowledge, and it's always tricky to say something that you probably have to correct at a later point in time, because then you will appear as not really knowing what you're doing. It's also difficult if you kind of promise to do something and you can't keep that promise, so kind of overcommitment, and in the end kind of not really being in a position to perform. So always important to better think twice what you can actually do. But on the other hand, I mean, keeping silent is also not a solution, or not in each case. In particular, if people outside of the organization have already heard about that there is something going on. And then there's always also the question of, what do you really say? Do you want to apologize? Some companies very early on start thinking about whether it makes sense to admit responsibility, which is something where we would usually say, well, as long as you do not know what has happened and you do not know kind of the scope and extent of the allegations, is always dangerous to admit liability, because you don't really know what you're admitting to. And probably one last thing before handing back over to you, Juliana. I mean, it's also in a dawn rate situation, usually from my perspective, also important to keep it, try to keep the dawn rate a secret. Also kind of make sure that the employees do not talk about it, do not kind of inform their relatives or something, and then like their relatives or spouses or so, because that also increases the risk that there are rumors out there that you do not want to have, because it might create negative publicity for you.
This is very interesting, Kerstin. Thank you for guiding us through the German perspective. And it is indeed pretty similar to the Brazilian reality as well. And I would like to discuss a little bit about the internal investigation itself, especially the fact-finding process, which for me is a key part of any investigation, and often the most time consuming, because it typically involves collation and review of documents, identification of relevant material, interviews with potential witnesses and key players to better understand the environment, report lines, the context of the investigated facts. So Ludmila, what do you think about it? Would you like to shed some light with respect to the internal investigation itself?
Yes. I think that the point here is that the internal investigation works for a lot of things. The more obvious one, it's like to investigate and to know what happened, but it's not just this one, and we are talking about knowing what happened later. But there is another thing that it's not so obvious, that we were talking about communication in the end of the last topic, and the internal investigation, it's part of the strategy of communication also, because if you are thinking that you are trying to limit the communication, if Kerstin in a very right way advised us that not talking anything is terrible, because silence, if you're silent for that, so you are agreeing with what's happening. But in the opposite, if you talk a lot, what are you going to talk? What are you going to say? You don't know what happened yet. You don't know all the facts. You don't even know the investigation objective, because usually you have less information on that moment than sometimes the media have. I had a case, we had a case in our firm, me and Juliana, that the first report that we saw from the investigation, we saw it on the news, the TV news show in that day. So we took pictures from the screen of the TV, and then we put some filters to try to read the report, because we didn't have access to the report prior to the media have. So they had access before us. So they were like putting that on TV, the police report. And so we were taking pictures like crazy and trying to read from the TV. So sometimes I say that they are the best interns that we have, the media reporters, they are the best interns that we have, because they have a lot of information that we don't have on that moment. So we were talking about, so the internal investigation is part of this, the communication plan itself. Because usually when we talk about what the company should state in this very first moment, so the first one is that the company is committed with the best practices of compliance ever. So it is a serious company. The second one, we are collaborating and we are being proactive and we are open to the authorities. And so we have this proactive and collaborating moment or decision. Not collaborating as self-disclosing, but collaborating like saying that we are not denying and we are not closed for that. And the third one is that the companies using and hiring the best services providers and lawyers to investigate and to see. We don't use usually the investigation word, but it's like the meaning is that this ing is happening. So we are analyzing, investigating, gathering. So, because this is important and this is real. So I'm saying that I'm committed with the best practices. I'm not, I'm collaborating. I'm open for everything that the authorities need. And the third one, I'm going to look inside myself. But this looking inside yourself, and it's not so easy because there is a method for doing that. And the methodology is important, not just because we want the evidence that were gathered, they are valid, so they can be used someday if needed. And if you are talking, for example, about one executive that caused damages for all the company with his own conduct, for example, so we need to guarantee that his rights of privacy, data privacy, they are preserved, but at the same time that the company is doing everything that the company can to investigate and to guarantee that the cow is never going to the ditch anymore, right? So this is why the method, it's so important during these investigations. So as Juliana started, I think, and Kerstin, I think that we had discussed this before, me and her, and we really like discussing about this webinar. And it's very clear for me that the most important part of this investigation, it's the scope of the investigation. Sometimes we stay like we spend, I don't know, 5 days, 5 precious days, because they are the first 5 days. But sometimes we keep deciding during 5 days, what are we going to investigate? Who is going to be hired? Who is going to be hired to be together? The forensic, the PR company, and who is going to be the report committee? For whom are we going to report the investigation? And last but not least, and maybe the most important thing, what are the facts and the person and who's being and what's being investigated on that moment? Because it's very tempting. Once we start an investigation, there is a temptation that we start to investigate everything. And it's normal, because the directors and it's important for them to know, no, I'm not going to stop you to investigate anything. I want to see everything wrong in the company right now. It's going to be impossible, because you are going to find things that are not connected to that. And maybe you don't want to see that on that moment, then you can do it later. And that's why the compliance programs and the auditing, the internal auditing, the compliance auditing, this is important for this constant investigation. But we are not talking about an ordinary investigation. We are talking about an external investigation. It can be internal, but with external help. We are talking about an external investigation initiated because of a crisis, a downgrade, a police or criminal or a regulator investigation. So it's not a compliance typical investigation. So we have to be very careful not to get on this temptation to investigate more than we need to. We have to focus, you have to decide. Once this is established, so you have this plan, you have the next steps, you have hired the partners, the forensic, for example, if you are talking about data collection, maybe sometimes you need, if you're talking about data privacy or a cyber crime or a cyber attack, that is not our case here, but sometimes you are talking about that. So you have to have someone from technology and some company that can help with these tech investigation, this investigation more connected with the systems and the computers. So then it's, once we have this team together and we have defined what are we going to investigate and to whom we are going to report, then we start doing it itself. And then there is a method, and this is not a webinar about internal investigation. We are talking here about internal investigation related to a crisis management. But it is important to state that if we are talking about this crisis management, this internal investigation, we will have to co-live, we'll have to live together with the investigation coming from the enforcement, law enforcement. So you are investigating here, and at the same time you are being subpoenaed, you are receiving a subpoena to answer something, and you're going to receive a request of delivering some documents or some contract while you are investigating. So what is important here is to understand that the external lawyer that is investigating and it's doing that, it's an independent and external investigation. This lawyer is not going to is not going to interact with the investigators, the authorities, like in a position to defend that moment the company. It's important to have this independent and external lawyer doing the investigation and showing, using that method and showing that everything that the company can do to realize what really happened inside, it's being done. So this is what this is why we have to keep the privilege. So we have a lot of questions about privilege, and Kerstin maybe can even, I know that this is very, the concept of privilege, information, attorney-client privilege in Brazil is different from the outside. But if we are talking about multi-jurisdiction, for example, proceeding, things that I do here can interfere in Kerstin's job once she's using what I collected here, or what about the interviews I did here, if it's a lawyer, not a lawyer, if it's recorded, not recorded, if it's written, not written, my notes, where it's where I put the notes, which kind of cloud we are using to keep the documents. So this has to be discussed together if we are talking about more than one jurisdiction. And Kerstin will talk about a little about this, but this has to be discussed together, all the jurisdictions, because this method is not just something for because we want the method to be happen. It's to be valid, and not to put to give more information than you need, and more than that, to not to make a wrong decision about the right timing of disclosing things. So we have to investigate, to be independent, really independent, to have a report, a very, very clear and independent report. We cannot report for the executive, for example, that is being investigated. It's something that it can be weird, but sometimes they think we can, right? We are not going to report to the executive that it's being in the middle. I'm not saying that he did or he or she did or didn't do anything wrong. I'm just saying that it's not him. He cannot be my report. And so it's independent, external. The evidence should be valid to be used outside or inside. You have to have a very clear and limited scope to be objective and fast. And you have every time to keep touching bases with the other jurisdiction to see what I do here, what we do here in Brazil, for example, impacts in Germany, for example, in our example here. So I think that, and Kerstin is going to talk a little bit about this, and I can back for the decision and the results, but I think it's important to understand for Kerstin what are the impacts for the German in our investigation here in this example.
Yeah, there are definitely many concerns that may arise during this fact-finding phase, such as the privilege, as you mentioned, Ludmila, but also data protection, potential issues when transferring data to other jurisdictions, conflict of interest that may arise during the internal investigation, and so on and so forth. So I think, what do you guys think about the do's and don'ts in an internal investigation? I know we have been discussing a little bit of that in the past minutes, but in your view, what should be absolutely done and what shouldn't be done at all? I don't know if we would like to talk a little bit about that.
Kerstin, I think you can start, yeah.
Yeah, I mean, but probably let me just say a few words. I think in addition to Ludmila, what you said about investigations and also privilege, just kind of from and more generally, what is important here. I mean, from my perspective. You said it's important not to investigate more than you should investigate to, so really get the scope right. One thing that is particularly also important from a German point of view, if you have authorities investigating at the same time, like the prosecutor investigating the same matter, you should always make sure that you do not do anything that would upset the prosecutor. For example, if they haven't interviewed any witnesses or accused people who are your employees or your former employees, then you can create a very, let's say, difficult situation for the company if you speak with the individuals first and conduct your interviews with those individuals as part of your internal investigation before the prosecutor had the chance to speak with them, because they might see that you have kind of told them what they should say to the prosecutor. So they might accuse you of obstructing their investigation, which is a nightmare for the whole climate and atmosphere. And also, I mean, this aspect kicks in at an earlier point in time, namely at the phase of the dawn raid. Often when we are in a dawn raid situation and we are assisting the company and there are kind of a dozen of prosecutors and they are searching the different offices of the people, then I mean, not everybody is around on that day, because I mean, naturally, people don't know that the authorities are coming to do a search. But sometimes the question comes, well, this managing director or this employee, he's not here. Can we call him just to let him know that they are currently searching his office? And I mean, our advice in this scenario is always, don't inform anyone of any matter that's going on without having checked with the prosecutor, because it might be that's often the case that at the same time there are other teams from the authorities performing the search at the private home of this individual if he is an accused. But it's just important not to interfere or create the impression that you interfere with the investigation of the authorities. In particular, if you as a company want also going forward adopt a cooperative approach and want to establish a good kind of working relationship, if one could call it like that. So it's important not to spoil and ruin everything at the outset. And probably one practical tip, I hope this also applies to Brazil, but at least it's true for Germany. If you have a dawn raid, and Ludmila already talked about crisis plans that should be in place, but it can help. It can really help if you know where your documents are, because if it's a large building, a large organization, but the prosecutor is just looking for specific information referenced in this search warrant. I mean, very often we've seen that the prosecutor just remains sitting in a kind of conference room, and they are satisfied if the competent people, if they compile the files and the binders and bring it into the room for the prosecutor so that they can seize it. That's fine. But if nobody knows actually where the information is, then you have the authorities everywhere. And at least in Germany, if you try to stop them from walking through your building, then you can even create an own criminal law risk for you, because you're trying to stop them from performing their work. And this is probably, I mean, I think this is important for the physical documents, but probably even more important for electronic files, because that's always nowadays the major part, because everything is somewhere out there on cloud servers whatsoever, and that's what usually the authorities are interested in. And that's usually, from my experience, where a lot of problems come up, because the servers are not necessarily in the jurisdiction where the physical dawn raid is happening. So it is then tricky for the prosecutor. It's tricky because they can't access kind of the documents which are outside Germany, the EU, which are somewhere else around the globe. But it's also for the company important to know where it is, so that they can decide whether it would be fine to grant access or to make that available to the authorities, bearing in mind the various data privacy laws, and also this regime about data privacy becoming more and more stricter with more and more fines. So this is kind of just, and I think that somehow leads into the question: what are the do's and don'ts? Just one further point on privilege. This is something which is usually particularly important if you're dealing with the UK or with the US. US-based clients or UK-based clients, they're often kind of disappointed when they ask me about privilege in Germany, and I say, well, I mean, the concept of privilege that we don't really have it, because in Germany it's just like we lawyers, we have a duty of confidentiality. We're not allowed to say anything unless the client allows us to speak about their case. And there's a lot kind of movement currently in Germany when it comes to how far does this kind of, because this duty to keep it confidential, that also gives us the right to refuse testimony if we were kind of summoned to testify against our client. And there is a huge discussion here in Germany around to what extent that protects companies from the seizure of investigation reports or interview notes from internal investigations that have been prepared by law firms. There was we had well, at least here for Germany, very, very prominent cases, because US international law firm, it's kind of known everywhere as the Jones Day case in Germany, that had been searched in Germany in the context of the diesel emissions scandal, and had then later on the opposed that search and seizure. And this case has gone up to the Federal Constitutional Court here in Germany, which ruled that in that particular case, I mean, that was that search and seizure was fine, although I wouldn't say that's a decision that holds true for each and every case, because usually if there are already proceedings against the company going on, or cases in which they are imminent, so to say, then and you have sufficient sufficient power of attorney for that client, then I would take the view that this should protect the company as best as possible. Although, I mean, we've seen the tendency over the past years that the authorities are becoming well, greedy is probably not the right word, but they always want more and more and more information. So this is something that one needs to bear in mind here. And then before handing back to Ludmila on her view on the do's and don'ts, I think the do's in an internal investigation, one of the most important do's is everything that's here on the slide qualifies as really, really important do, but probably it's also to be prepared, because I mean, it's like when you're caught in a car crash, or you're just a witness of a car crash. I mean, nobody really wants to witness that, but if there are people who are injured, you need to know how to help them. I mean, so it's important to have the necessary skills, although you never want to use it. And that's the same kind of for any crisis situation. You want to have a crisis response plan. You want to know what you need to do so that you have at least some kind of structure for the for how to kick that off, how to, at least if it only tells you who to call. For example, if you have at a company, if you don't have any instruction how to react in a case of a dawn raid, then the people who are sitting there at the front desk, they're completely overwhelmed and they don't know what to do. They don't know who to call. They probably just let the authorities in, and then probably nobody else knows. So it's just so important to have a plan and to be prepared. And then always, I mean, the hope is obviously nothing will ever happen, but better be safe than sorry, I would say.
Being prepared is the key. I agree with you, Kerstin. And Lud, would you like to discuss a little bit about the don'ts, maybe?
Yeah, I think it's very, I couldn't agree more with Kerstin, and I think that maybe we can move to the next slide about don'ts, because what to do, like what not to do, right? Because, okay, we have to make it simple, make it small, have a very, having the group, the decision makers from the company, so we can be fast. We can have it in a small group. The less is the better for the decisions. But what sometimes it is like human for us. The denial, it's a human proceeding for the client, and it's very tough for us. And I was discussing this with Kerstin and Juliana before the webinar, that sometimes in this moment we are kind of shrinks for our clients also, because we have to guide them through this new situation, because usually, of course, the client, this is not the core business. The client is not dealing with that, has never dealt with a situation like that. So one thing that it's human and it's very common, it's the denial. It's like underestimating the things. So no, it's going to be okay. So maybe in a week you can conclude the internal investigation, and so that is like underestimating the proceeding, underestimating the allegations and the next steps. So I think this is, do not underestimate. Keep your heart open and trust your team, trust your external lawyer, trust your team, because sometimes they will have to spend time doing things that apparently are not going anywhere, like hiring the specific forensic or analyzing, deciding the search terms, deciding the custodians, deciding what, and at the same time, things are going and happening outside. But trust that sometimes we should spend more time deciding this or that and looking to some allegation before. So do not underestimate the allegations and the time that you have to take to investigate. Don't make promises you cannot keep, of course, and promises not just for the authorities, but promises for your stakeholders, for your investors, for your customers, for your employees. Like, you don't know yet. So don't say, no, we are not, we don't have anything wrong. I promise that we are delivering my bank accounts and the bank accounts are open for anyone. Do not make promises you cannot keep. The promise that we can make is that we are investigating, and the company assures the commitment to have an independent and external and clean and clear investigation. This is the only promise that you can make. Otherwise, you cannot keep. Maybe you are not going to keep it. You can't realize that things are worse than you thought, and that you will have to make decisions, tough decisions, just like self-disclosing, such like asking for an agreement. Don't finish the conclusion. This is very common. It's like jump to the conclusion too quickly, but document everything since relevant may change. Because usually they want the conclusion. Give me the findings. Give me the findings. Give me the final conclusion, and you don't have the paper trail needed to have that conclusion. Don't panic. It's obvious. Even remain calm and train your team to remain calm. And calm in this case comes with trust. So trust your team, because the calm here will come with preparation. If you have so, it is better. But if you don't, you need to build to the trust. So I think that the do's and don'ts are trust the team. You are not going to hide anything, but you don't have to show and promise things that you don't know yet. The point is, you don't know yet. You will need to find out. And then I think we are moving to the next and the final topic of these. And then once you have the final conclusions, and it can be something very clear, but at the same time, you can just realize that you don't have a final conclusion like that allows you to decide very clear what you have to do. But once you have the final conclusions, and then using that method, doing the things that the way they should be done, with an expert hired, with a communication plan, with the method and investigations, interviews, document review, search terms revised. Sometimes you have shadow processing during this proceeding. You have the auditor, the external auditor shadowing the process. Sometimes you have the external, the foreign law firm, for example, Kerstin shadowing my investigation here on behalf of the client in Germany, because she will have to trust my investigation here if she wants to use it there also. So let's do this time. Let's take this time and then decide whether to self-report or not to self-report. And I think that Juliana, she's an expert now, because we are dealing with two cases here about the amount of authorities that you have to decide to self-report. Ju, I don't know if you want to introduce this issue here about self-reporting and cooperation.
Yes, absolutely, Lud. This is one of the most important and strategic issues for companies, where and whether to self-report, especially here in Brazil. There's also the question of to which authorities should a company report. As Ludmila and Kerstin said, we have many regulators here that may have jurisdiction over the same facts. Any decision to self-report then will require a very careful assessment of the key risks and benefits. This should be carefully considered by the company. And I would like to hear from you, Lud, what are the main challenges in self-reporting in your view?
I think that challenges is if you decide to self-report, the next question that for me is more important than the first one is to whom you will self-report. Because as you said, we have more than one authorities. We have multiple authorities that could interfere on this proceeding. They are not sitting on the same table yet. It is better than used to be. The beginning of this, before car wash operation, or even during the first agreements in car wash operation, it was even worse. because we really didn't have the possibility to have more than one authority in the same table. Now we can have federal prosecutors, we can have AGU and CGU, we can sometimes even can put together more than one, the state prosecutor and federal prosecutor together, accepting one the deals from another, the conditions from the other one. So I think that now we can have CAGI and federal prosecutor together. So I think it's better, but the question is if you are going to self-report and to whom you are going to self-report. It can be good. Self-reporting can be, we have benefits from self-reporting, but we have risks at the same time. The benefits here in Brazil, you can avoid criminal and administrative enforcement proceedings. So you can even have, now we have the possibility of these, not just the deferred prosecution agreement, but we have non-prosecution agreements, possible non-prosecution agreements here in Brazil, either to the individual or to the company in another, not a criminal, but administrative and regulatory investigations and proceedings. You can manage the content, and so you can content the information and the damage and the image that it's going to be reported. You can reduce significantly the penalties if you are not going to be able to negotiate a non-prosecution agreement, but you can reduce the penalties. And you can minimize and you can control the reputational risk, because you can say that the company it's repairing what eventually came wrong. So you can control the images, the image and the public image from the company. At the same time, you can have the problem. You have risks. You can waive the privilege of part of the investigation. You can have to show some pieces or some parts or some acts from the organization that are not good for its reputation. You have to admit wrongdoing sometimes if you are self-reporting. And then, although you are promising that this is not going to happen anymore, this is what Kerstin said, the last one, but you will have to admit that happened before. So you have a problem here related to the image and to the public reputation from the company. And you can have like the interference from the authorities inside the company. You can even have monitorship, and you can even have something that is more not just like penalties, but you have to assume and to commit with a big period of time after you self-reporting. So I think for here in Brazil, these are mainly the risks and the opportunities of self-reporting.
Yeah, it's definitely not an easy decision, especially depending on the experience of the authorities that you have to negotiate collaboration agreements. But if I may add something, Ludmila, here in Brazil, I think that one of the main benefits that we may also have in self-reporting is that we can avoid blacklisting, disbarment, and minimize the risk of disgorgement. And this is a saving in the end. But again, we need to do it very carefully and know exactly with whom we should negotiate all these collaboration agreements. Otherwise, this may be an even bigger problem than not self-reporting. And Kerstin, what would you add from the German perspective?
Yeah, I think from the German perspective, or more from a view when you have a cross-border investigation, meaning that you have authorities in more than one jurisdiction investigating at the same time, then I think it's a fair summary. As you said, it is not an easy situation in such scenario, and there is no one size fits all answer, because it's always a decision that has to be taken individually in each and every case, and in every case you have to weigh the advantages and disadvantages before making the decision, taking into account that whatever you say in one jurisdiction may have an impact on the other jurisdiction. But what you always should have in mind, if you have such cross-border case, the authorities, they are increasingly working together, increasingly cooperating, not only when it comes to information sharing, but particularly when it comes to information sharing. I mean, there are the usual official ways of information sharing, but there might also be kind of informal conversations or so where they exchange information, and also there are at least when we are what we are seeing also authorities from various jurisdictions really investigating together in joint investigation teams. For example, I mean, there is one case which didn't have a Brazilian nor a German angle, but still is a kind of perfect example, so to say, for the dimension that such cross-border investigation can have. For example, the Airbus case last year. Airbus, they reached a really record-breaking 3.6 billion euro settlement with the UK, French, and US authorities in relation to bribery and corruption allegations, following basically more than 3 years of a joint UK-French investigation and a parallel 2-year US investigation. So it's not only a theoretical risk. The authorities, they are working together, and you should always expect that they find out. So what you tell one authority will at some point in time be in the possession of the other authority as well. So you need to have a strategy. You need to have a comprehensive cooperation and disclosure strategy. And the key issues basically are when you have the risk, or when you actually have various or several investigations in several jurisdictions going on, then it doesn't help you much if one investigation in one country is finished and the others are going on. So you want to generally you want to achieve a settlement and try to achieve finality by seeking to settle with all involved enforcement authorities at the same time. And in this respect, when companies are deciding whether or not they shall report to multiple enforcement agency, there is much benefit in trying to determine at the outside which of the authorities is likely to enjoy primacy, and then to invite the other regulators to somehow coordinate and cooperate in their investigations, because very often they are not at the same level in terms of how far their respective investigations have proceeded, and sometimes also the speed of the investigation differs. Some jurisdictions, the authorities are faster than in others, and this all kind of plays a role. And you also need to consider when you self-report in terms of timing and the sequence of events, because usually when you self-report and when you want to cooperate, you want to have some benefit from that, like Ludmila mentioned, reduced fines, for example, or hopefully no fine at all. But I mean, the information that you provide is only valuable if the authorities do not already know everything, because if they already know everything, why should they give you credit for your cooperation? So this is something that needs to be considered as well. And as I said, the messages that you send out in the various jurisdictions, they need to be consistent. You shouldn't provide conflicting messages because of the exchange of information between the various authorities. So as I said, you need to decide in each and every case individually whether it makes sense to self-report and cooperate, and where. But generally speaking, I would say that the later a company decides to cooperate, the greater the risk is that the cooperation will not be viewed as valuable as if the cooperation had been offered at an earlier point in time. And in any case, you need to thoroughly assess the risk and benefits, and also keep the decision, once you've self-reported, also keep that decision under the review throughout the life cycle, because also the scope of the investigation by the authorities might change, and it might well be that at some point in time it is not appropriate or not beneficial for you to still cooperate in respect to a certain aspect. But that's that's again a decision that needs to be taken in each individual case. And another thing you also need to consider is what kind of cooperation you want to provide and how you want to cooperate. In this respect, it's important to make clear what you want to do and what you want to deliver in order not to create the wrong impression. Because if you, and we had that before, if you offer too much and then cannot deliver, then this is rather detrimental than helpful at the outside. And this is, I mean, we've all talked here about the voluntary self-reporting for your benefit. There are, of course, also situations where you don't have a choice because the law requires you to self-report an incident to the competent authorities. There are mandatory reporting obligations out there, in particular if you've got a listed entity, like here in Germany, listed entities, always in cases where the stock price could be affected, then such scandal, such issue can trigger ad hoc notification obligations. So that's something that you carefully need to watch out for and assess in each and every case. So unfortunately, no one-size-fits-all answer here.
Yeah. Thank you very much for this, Kerstin. This is very, very helpful. Let's discuss a little bit. There was something that was very interesting that Ludmila said relating to the results of the investigation. In case the internal investigation has not pointed to any documents that confirm the allegations made, for instance, by plea bargain agreements in the context of a governmental investigation. After you conduct a very detailed review, you were comfortable enough to say that you did not find any, you did not confirm any corruption allegation. On the other hand, the document review sometimes points to the existence of service provision contracts with third parties with very broad and generic scopes and no corresponding proof of service rendered, although the payment sometimes was confirmed to those suspicious third parties. So is the end of an investigation also the time for a lessons learned session? What do you think about it, Kerstin?
I think you mentioned two kind of important and important points worthwhile discussing. I mean, first of all, it's always the best thing if the investigation ends without the allegation being substantiated. So when you can say, okay, there's nothing to the allegation, so nothing to fear from this particular case. But very often the investigation, and when you start looking thoroughly at things, you come across other things that, well, might sound suspicious or might give rise to at least have a further look. And in the example you just gave, when you've got kind of contracts where, well, you don't really know what the people who are getting paid for that what they actually do, I mean, that's often what we call a red flag for kind of corruption risk. So it might well be that while finishing one investigation and closing it with a positive result, you might have the need to start and look into another issue. So that's of course something that can always happen, but regardless of how the investigation ends, whether it's with positive or negative outcome, I think internal investigations at the end thereof is always a good point in time to look back, and as you said, time for lessons learned, because investigations, they may reveal weaknesses of your existing compliance systems. They may reveal the need for you to make amendments to your compliance system. So for example, at this stage, when looking back, you might want to ask yourself questions like, are there any weaknesses to my compliance system? Is there anything that has been discovered here? And there, in this respect, you will want to look at the root cause also and review the lessons learned therefrom. And then you will have to ask yourself, well, if there are any weaknesses, is there the need for any remedial actions? Is it that my systems and controls, that they need some kind of improvement? Is it that new procedures and new mechanisms can or should be put in place to just prevent the situation or similar situations from happening again? Or is it that even my systems and controls, that they need improving, or, well, should I even introduce some if I don't have some already? So you need to ensure at the very end that you do not waste the opportunity to learn something from the investigation. And also you need to ensure that whatever conclusion you draw and whatever your lessons learned are, you need to ensure that they are communicated appropriately to the relevant people within the organization, and that they are actually implemented, because it's always good to have a kind of plan, but if you don't act on the plan and don't implement it, it doesn't help you much. And in any event, you should, if you don't already have, implement a kind of regular kind of checks of your compliance management, your compliance management system here. And this is also so important because compliance structures and the compliance management system as such is obviously a means to mitigate risk. Because first of all, if you have an appropriate compliance system in place, then this obviously prevents people, hopefully, from behaving badly and committing offenses. But also it might help you to achieve any reduction in the fines if you can show that normally you have sufficient control mechanisms in place, but there was just one person within the organization who simply decided to cross the line and violate those provisions. So definitely, Juliana, I would say the end of an investigation is always the right time for lessons learned. Take a look at your compliance system, see whether it's kind of fit for the future or whether it needs some kind of modification.
Very good. Do we have any questions from the audience? Because I have a question, another one. I have many questions actually, but I would like to ask something to Ludmila, because how should I interact with the authorities? What if the lawyer is not there during the dawn raid? Am I allowed to answer questions, for instance? If the authorities insist on questioning, what should I do? Is it possible to be questioned during a search and seizure, or should I be taken to the police station? I would like to hear your thoughts on that, Ludmila.
Yes, I think that we even have one question from the audience here, kind of related to that. If they don't want to, they want to expand the scope, and how are the limits that you have to deal with the authorities. As I said before, if you can ask them in Brazil, at least the authorities during the down raids in Brazil, they are trained because of they also are afraid about that act being nulled after that, because of some kind of illegality by them. So they are very careful about the limits of that. So you can ask them not to, you can ask to see documents, you can ask, why are you looking these? We can ask for copies. And of course, it's a questioning proceeding. Like, you're not like limiting their activity, but we are asking them with being very polite on this relationship. These limits are usually, and these questions, we should ask for the external lawyer to do it. It should be a lawyer to do. But if you don't have, or if you don't have the time, or if they didn't want to wait for the lawyer, so what you need to assure is that at least that everything that it's being done, it's been documented. This is the only thing. If you cannot avoid them to do or don't do something, at least you have to be sure that everything is documented, so that you are taking pictures, that you are taking copies, that you are seeing the same thing that they are seeing, if they are fulfilling the forms. For example, if they are gathering documents from the legal department, the internal legal department, so they can be privileged documents. So to show and that the package of documents coming from the legal department should be identified as coming from the legal department. We are not saying that we are going to ask for privileged documents, but at least if someday we want to question that, we can identify the pack of documents that were collected from the legal department. And just like Kerstin said, the more organized you are, company, with your documents, either digital documents or physical documents, the more organized you are, the best are, the more chances you have to not have this seizure of more than you needed to be seized. So what is important here, you can make questions, you can impose limits, but if you can't, if they don't attend you, at least you have to document everything that they are done. The second thing is about them questioning or of employees or directors or board members from the company during these proceedings. It is not allowed for them to interrogate or to collect or to proceed listening and collecting declarations from the company. It is a different decision, so they can subpoena someone to go to the police department later on, but they cannot use. So this is this is what we indicate since the beginning. No one has to talk anything. They cannot make questions regarding the facts to the employees or the director. They just can make questions about the localization, where the documents are, and about like, how is this organized? Where can I find these? Where can I find that? But they cannot make questions, and they cannot use this moment because it's the limits are to search and seize documents. If they want to have the declaration, so they can subpoena at that same time. They can say, listen, here is, you are requested to be in the police department, or that today, tomorrow, with your lawyer, but they cannot use that moment to make questions. So the orientation here is not to answer these kind of questions.
Very helpful. Thank you, Ludmila. There's another question here from the audience that is very interesting. It says, when a crisis situation of this magnitude takes place, I imagine that there would be executives directly involved in the facts and that would absolutely panic and put their self-interest before the companies. I mean that these executives could themselves hire external lawyers and try to celebrate an individual collaboration agreement. Is there a way to better handle situations like this and avoid individual acts of self-preservation over the greater strategy? Kerstin, would you like to comment on that?
Yeah, I mean, I'm a bit conscious of time, but I think this question should still work. So I think overall, it depends, I would say, on the personality of the executive, basically. I mean, there are people who would panic and others who even though they are accused of having done something wrong, they are really confident and believe, well, that's not the case, so they don't panic. But assuming, and that was the question, they panic and hire an external lawyer. I mean, obviously they have the right to hire an external lawyer. You cannot prevent that. And if they are the accused in criminal proceedings, at least in Germany, I mean, they must have somebody, because otherwise they wouldn't get access to the criminal files and they cannot properly defend themselves. And it would be really stupid if they didn't have, I mean, I have to say that frankly, but it would be stupid if you are an accused in a proceeding and you don't have a specific criminal defense lawyer. I think what the company needs to make sure in such scenario is that this executive, who would normally be involved in all relevant decisions for the company, that he is not involved in decisions as regards the internal investigation or the way how the company wants to cooperate and liaise with the authorities, just to make sure that there is no kind of conflict of interest in that respect. When it comes to the question of, well, will the executive and his external lawyer, will he go to the authorities and try to achieve a better outcome for himself at the expense of the company? I mean, in my experience, usually it's usually that does not really happen if the relationship between the company and the executive as well, because people are generally, at least for quite a while, on the or try to be on the same side and try to achieve the best possible outcome for everybody. So what the company should watch out for is that the lawyers or the criminal lawyers advising the company and the criminal lawyer of the executive, that they are in constant contact, that they have a good relationship, that they try, to the extent also this is legally possible, to somehow look whether any defense strategies can be aligned. I mean, we had a case where we had kind of 15 accused individuals, including former and current management, and in that case, the defense lawyers of the individuals, they even kind of stepped back and didn't seek to negotiate anything individually with the authorities, but just allowed us, for the company, to investigate the case and try to, well, establish the facts, and then the individual defense lawyer basically also benefiting from the outcome of the internal investigation that the company had done. So it's always, again, a question of the individual case, but if you manage to establish a good relationship between executive and company and the respective defense lawyer, this is something that is in most cases manageable.
Yeah, I agree with you. This is a very common problem that we have here in Brazil as well, the possible conflict of interest and how to converge the different interests in this crisis situation. Well, I think we are reaching the end of our discussion now. I can see that it has been very productive. I would like to thank you, Kerstin, and Ludmila once again for a great contribution to this panel. Thanks also to the chamber. I'm pretty sure that the audience was pleased to know about how to react to a crisis situation. And also I would like to thank the audience for your attention. Wish you all a good day and hope to see you soon in our next webinar. Have a nice day.
Have a nice day. Bye-bye. Thank you.
Thank you.